Good evening. My name is Phil Howard. I'm director of the Oxford Internet Institute, and it's a pleasure to welcome you here today and to introduce my colleague, Dr. Sandra Wachter. I was trying to think earlier about what kind of AI joke I could start with, because it's normal for the 2 minutes, 1 minute of introduction to start with a joke. It's a difficult time to joke about the role of technology in public life. In some days it feels like the house is burning, right? And some days it feels like there are still some important opportunities ahead. And I think we spend a lot of time discussing the ethics of AI, the way technologies could shape our futures and could bring some truths to life, help us improve the quality of life. And it's also important to remember that there are some fairly clear rules we need to set in the near future for what AI will do for ourselves. To some degree, the Chinese government might set some rules for its AI, and the European Union might set some rules for AI in the European context, and the Americans may never regulate any of this. But we're at a very sensitive moment now where the guidelines that we pass to engineers will shape your futures, will shape the opportunities that are available to your children. And so I'll pass to Sandra to say more about how she's thinking about this future. Just let me say 30 seconds about the Oxford Internet Institute. We're a department in the university, and what makes us interesting is that we're about a third humanists and a third social scientists and a third computer scientists. And our computer scientists have to learn, if not the theory, at least the craft of argument in the social scientists. And our social scientists have to learn to code or at least understand the implications of code. And our humanists have to do the translation work. In fact, it's often our humanists that craft the toughest of questions to answer and then translate what we learn when we build new tools into a storyline that makes sense for understanding where we're all going. So as we listen to Sandra for the next 35, 40 minutes or so, I'd like you to know that this is being recorded for our website for down the road. Also, when we get to the stage of asking questions, it'll be very important to use the mic for questions so that we can have the questions for posterity. There's several mics around the room. Sandra will handle her own questions in batches, but please use a mic when it comes to that moment. So, please, let me introduce Sandra Wachter.
Thank you. Thank you so much for the introduction. Thanks so much for all of you to join me to talk about data and AI. I'm very excited about that. The talk of my title is Show Me Your Data, and I show you who you are. The talk is roughly centered around a new paper that I just published together with my colleague Brent Middlestead, who is also a fellow here at the Oxford Internet Institute. And we called the paper A Right to Reasonable Inferences, Rethinking Data Protection Law in the Age of Big Data and AI. So we published that piece a month ago. And I think since we published that piece, we go around apologizing to everybody because the piece is 90 pages and 400 footnotes. So it got a bit out of hand, but it took us quite some time because we wanted to make a very, very important point, because we feel that currently the legal structure is not guarding against the novel risks of AI. So I'm going to present around that paper and try to give you the essence of it. And the essence is basically to say, we live in a big data world. We know that we're using technologies every day for private purposes, business purposes, and whenever we do that, we leave a data trail behind. This data is being collected, it's being evaluated, it's being assessed, inferences are being made from that data. This data is then being used for decision-making purposes, for example. Data is being used to decide if somebody should get a loan, if somebody gets hired, fired, promoted, if somebody gets insurance, if somebody is admitted to university, if somebody has to go to prison. So very, very life-changing decisions. So in a way, the data that we leave behind shapes our identity, shapes our reputation, and steers our path in life. And I feel because this is happening, we might need more meaningful control over how we're being assessed, and therefore we're calling for a right to reasonable inferences. So because the talk is called Show Me Your Data and I'll tell you who you are, the first question is, who are you? And if you ask me that question, I could give you, for example, 3 pieces of information. I could tell you I'm a lawyer. I could also tell you that I'm Viennese. And I could also tell you that I'm a vegetarian. All those 3 facts are actually true about me. I give you this information, and then I'll leave it up to you to make whatever you want of it. And from this information, from the input data that I'm giving you, you can make certain inferences about me. You could think, well, she's a lawyer, so she likes rules. She's Viennese, so she probably likes coffee. She's a vegetarian, so she probably likes animals. So all these inferences make sense. They have like a rational element to it. But if they're true or not, that's nothing I can control. I can go to you and tell you, well, I'm Viennese, but I actually like tea much more. And I could make you change your mind, but I have no control over what you think about me. I can give you some indication, I can have a dialogue with you, but there is no way that I have control over how to change your mind. So why is it different with AI and big data? And why are we calling for a right to be reasonably assessed? In order to unpack this claim, I wanted to give you a couple of examples that recently happened in the news that may shape and strengthen the argument. This is an interesting example just recently happened where Netflix is able to infer your race based on your viewing habits. So even though you never actually told Netflix anything about your race, based on your viewing behaviors, they're able to assess your ethnicity, and then they show you different content. It's the same movie, but they portray it differently to you, customized, because they have certain information about you. Another interesting example was here with Facebook. Facebook is able to infer sexual orientation about you. Even though you never identify with any kind of sexual orientation, they're able to infer if you're gay. And in this case, they were offering gay cure advertisements to people. Another interesting example is here. A paper was published by a couple of researchers, Microsoft Research, where they showed that they are able to infer Alzheimer's and Parkinson's disease based on your search behavior. So even though you are not giving us information, they're able to detect that. Another interesting example here with Alexa. Amazon just had a new patent where they are able to infer your health status based on your voice, and they can recommend you medicine based on that. And the last example that I have here is how third parties, for example, banking and insurance companies, are using data from Facebook or social network platforms, for example, to predict if somebody should get a loan. So they're not actually looking at your personal data, they're looking at your friends. They're looking at your circle of friends and who you encounter in your lives, and they predict if you are a reliable borrower or not. So how is it different from the information that I offer to you? Well, first of all, it's more data. It's not just the information that I actively give to you, telling you that I'm a lawyer, I'm Viennese, I like coffee. It's also very passive, unintentional, and also unavoidable. Whenever I interact with digital technology, I leave that data trail behind. I have to. My clicking behavior, my browsing behavior, my geolocation, eyes movement, tracking, everything is being tracked and evaluated. And the same comes true for third-party data. So it's not just my personal data, it's also my friends that say something about me. So it's more data. It is also more knowledge. Because you have so much data trail to leave behind, there's a very privacy-invasive and unforeseeable knowledge that is being created about you. And it's very inexplicable and very unintuitive. You know, Vienna is famous for its coffee, therefore the assumption that I like coffee makes sense. With big data and AI, it's not so clear anymore. The intuitive link gets broken. I don't really know what my friends say about me. I don't really know if reading The Guardian twice a week is a good thing or a bad thing, or how you assess that. And therefore, the intuitive link between what you do and what effect it has is broken. So it's more data, more knowledge, and it's more eyes. In the offline world, I can tell you something about me. You might tell it to another person, but you at some point might forget that. The other person might forget that. There is no forgetting the digital world. So you can replicate this information endlessly, and you can share with as many people as possible. And this phenomenon actually is different. It is different than we had in the offline world. And from a regulatory perspective, we actually acknowledge that fact. Big data is posing new challenges to the law. And one of the examples that we had is where the regulators acknowledged that we need new regulation was the right to be forgotten. The right to be forgotten is a perfect example of how it's necessary to come up with new legal frameworks to make us forget again. This was an interesting case in 2014 where somebody wanted to get personal information deleted, de-indexed from Google. And he went to court and wanted to have certain information about his financial situation removed. 20 years ago, the applicant was bankrupt, and this information ended up on the web. And every time anybody was Googling him, this information showed up. So this digital legacy was dragged over 20 years, and he said, this has been such a long time ago, and it's affecting me now. And even though this information was lawfully obtained, and it was accurate, the Court of Justice said, no, this is a privacy problem, and at a certain point, you should have the right to be forgotten. So if the right to be forgotten is something that was necessary in the big data world, maybe we should have a right over how to be seen. Maybe we should have a right to reasonable inferences, because that's the logical counterpart to that. And this is what we are arguing in the big data world. So with the examples that I gave you, and because I'm looking at it from a legal perspective, the first question is, what's the legal status of inferences, the inferred data that somebody is collecting about you? With the couple examples that I gave you recently in the past, they can be summed up like this. In advertisement, you can say, for example, that somebody is likely to be white or an homosexual. You could say that somebody is a reliable borrower. You can infer that somebody might be having an undiagnosed illness. You could infer that somebody is a good worker or not a good worker and should not be hired. All of this are inferences, predictions, and opinions. And what they have in common, they're either very privacy invasive, because we're talking about mental health issues, sexual orientation, race, and they're very predictive. So at the time when I make this decision, this cannot be proven because it's going to be in the future. So for example, if I'm a reliable borrower, if this decision was right, I won't know until I actually arrive at this point. And the same comes true with opinion-based things. What's a good worker? There is no way to verify it. It's a very predictive opinion-based assessment. So it's very privacy invasive. It's inferences that cannot be proven now or ever, and therefore are still affecting our lives. And this is where the legal problem comes in. If something is not verifiable, it's very hard to correct and it's very hard to contest. So it poses a legal question here. If we think about those inferences, those assumptions, the predictions that are being made about you, as personal information, it is not absurd to think that this might actually be personal data. If it is personal data, then we might have some new protections in Europe. As probably many of you know, the GDPR came into force, the General Data Protection Regulation, that is a harmonized new standard in Europe that tries to protect personal data in Europe and across the borders of Europe. So if inferences are actually personal data, we might be lucky and we're going to get more protection around that. And if inferences are personal data, I want to introduce two possible rates that could actually help manage you over how you're being seen. The first here is the right of access. The right of access is a right that everybody in Europe has. That means you can go to a data controller, to a company, to anybody, and ask them, what kind of personal data are you holding about me? So you could basically go to Google and say, what is it that you think about me? What are your inferences, your predictions? What is the profile that you have about me? So it would give you some accountability in the sense you would know what the company thinks about you. The second right that you might have is you have a right to rectification. You have the right to go to any data controller, public body or private body, and tell them the data that you hold about me is either inaccurate or incomplete. If it's inaccurate, you can get it corrected. If it's incomplete, you can get it completed. So if that applies to inferences, you would have the right to know about them and possibly rectify it, correct it if you think it's not correct. So the most important question here is, are inferences personal data? And this is unclear. We don't know yet. So we looked at jurisprudence in Europe, and it's unfortunately very unclear. We looked at the Article 29 Working Party. So this is a recommendation body in Europe that gives guidance and opinions on how to interpret the GDPR or data protection laws in general. They do that in a non-legally binding way. Nonetheless, whatever they publish has a lot of weight because very often data protection agencies actually look at their guidance and try to figure out what the law actually means. So the Article 29 Working Party has a very broad definition of personal data. So with the example here, Frank is not a reliable borrower, Article 29 Working Party would say, well, any information that relates to an identifiable person is personal data if it's either about the person, so it's about the content, which is clearly a fact here. It's also personal data if it has the purpose to assess you, then it's also personal data. And even if it's not about you, and even if it has not the purpose to assess you, if it has an effect on you, that means that it's personal data. And they clearly say that informations, opinions, and assessments are personal data. So it's a very, very broad, generous definition of personal data, which makes a lot of people dealing with data protection lawyers very angry because everything can be personal data, and therefore a lot of regulatory issues start. So this is the Article 29 Working Party. On the other hand, we have the European Court of Justice. So this is the highest court in Europe that actually has legally binding judgments. And what the court says, that's the actual law. And I want to talk about two cases here that show that we are in a very, very uncertain stage at the moment. The first case here was in 2014, where somebody applied for legal residency in a country. He wanted to stay in the country, but he was denied to stay there. The problem was he wanted to get access to the legal analysis of his case. So he wanted to get access of the assessment, the inference, the opinion that that person had about him, because he wanted to see why he wasn't allowed to stay in the country. And here, the court said, a legal analysis is not personal data. In fact, the court actually said that only facts can be personal data. Only input data can be personal data, which is a very, very narrow view and problematic. But it didn't stop there. It gets even worse. That person tried to use this right of access, this right to figure out what somebody's thinking about you, to get access to the legal analysis, was denied because it's not personal data. But even more bothering is that the court said data protection law does not have the purpose to ensure great transparency in decision-making, which I think is very troubling. So that's not the remit of data protection law. The second thing that the court said here is when that person wanted to use his right of rectification, so get information and rectify the legal analysis, the court said, well, you as the individual are not competent enough to assess whether this is accurate or not. If you do have a problem with the assessment, you would need to go to the authority that deals with immigration cases. So you would need to go to the next higher court, you would need to file recourse and go to an appeal, basically. So in this case, very clear, inferences are not personal data, and none of the rights that you would actually get under data protection law will apply. A second case that was a bit more promising just came out in December 2017. This case had to do with somebody that failed an exam. He wanted to become an accountant. He had to pass a test for that, and he failed. So that person wanted to get access to the comments and the assessment of the examiner and wanted to use his right to rectification again. In this case, the court was more generous and said, well, personal data has to be interpreted in a very broad way, and recalled what the Article 29 Working Party said, that everything is personal data if it's about the content, the purpose, or the effect. And in that case, the comments of the assessor, the analysis, what happened during the exam is personal data, and opinions and assessments are personal data, so much more broad, which is good news. However, the court also said that the definition of what constitutes personal data and whether or not the rights will apply will depend on the context, so calls for a teleological approach. That means that just because something is personal data, you don't get all the rights to it, and not everything is personal data. To give you a couple of examples here, the court talked about the exam questions. Do the exam questions, is this personal data? If you think about it, an exam question is data that is used with the purpose to assess you. So you could actually say exam questions are personal data, but the court said no, exam questions are not personal data. The second thing is, that makes also a lot of sense here, is the answers that the person gave. Of course, this is your personal data, but you cannot rectify your answers after you've written the exam, right? I think a lot of my students would like that, coming back after the exam and say, I would like to rectify my answers, please. But the court said, no, that's not possible. Yes, it is your personal data. Yes, it is your answers, but you're not able to rectify it. The interesting part is here, because the court actually said the comments of the assessor, the inference, the opinion that the assessor has, this is your personal data. However, the right of access might only apply in a limited way. So you can restrict it if it's necessary. And here it becomes complicated, because the court said, well, it's your personal data, but it's also the personal data of the person that evaluated you. So now you have to counterbalance two types of personal data. All of a sudden now becomes very complicated. And the court also said, yes, the GDPR actually gives you more rights, but especially when it comes to the right of access, the exemptions to the right of access are much broader than they used to be. So it's not guaranteed that just because something is personal data, you're going to have access to it. And the most complicated point was at the end, when it came to the right to rectify that. So the court said, in general, you could have the right to rectify the comments, but not the content. That means you would need to interpret the right to rectification according to the purpose for which the data was collected. So that means, of course, I cannot go back and figure out whether the comments of the assessor were accurate. I can only use it to make sure that my exam script was complete. So I can go, again, input data. I could have a right to assess whether all my exam sheets were collected or whether or not the exam sheets were mixed up with somebody. But I have no right to assess whether the comments of the assessor were actually accurate. And again, the court said, if you do have a problem with the way over how you're being assessed, you would need to go to an exam board. You are not the person that is competent to assess whether you have been assessed accurately. So where does this leave us? Again, just to summarize here. Again, the Article 29 Working Party is very, very generous and basically says anything can be personal data. It also says very clearly that all the rights that you have will apply. That means you get access, you can rectify it, you can even delete it if you want to. And the Working Party says the remit of data protection law is, in fact, to make decision-making more transparent and more accountable. Whereas the Court of Justice is unsure if opinions, assessment, inferences are in fact personal data. We have two contradicting judgments at the moment. But even if there are personal data, that doesn't mean that you get full access to them, and it most certainly means that you're not going to be able to rectify any of the analysis. But most importantly, what the court said in two of those judgments, in another judgment, in some free judgment, the remit of data protection law is not to regulate the content of decision-making, is not to make sure that the decision-making process is transparent and accountable. In a way, this makes sense because it would be weird if a data protection authority would all of a sudden judge over immigration cases. It would also be weird if the data protection agency would all of a sudden be the judge whether or not an exam was correct. However, we have decision-making standards very often in the public sector. We don't really have them in the private sector. We leave a lot of decision-making in the hands of the private autonomy. So you don't actually have a next instance where you could complain to. You don't have a right to get a job. You don't have the right to get insurance. You don't have the right to get a loan or be admitted to university. So because there aren't any decision-making standards for those important decisions, there's really no way for you to go and call recourse. And if data protection law is not there to make sure that decision-making processes are transparent, then we're gonna have a big lack over control over how we're being assessed. And I think it's different. I think it's different than usual decision-making, especially because we're moving in an area where we have more data, where we have more knowledge, and where we have more eyes. And therefore, I think we need to think about whether or not we should have certain decision-making standards, especially when it comes to the usage of big data. However, with the examples that I gave you, if I can just recall them here, those 3 examples show that inferences are being made about very sensitive attributes. And actually what data protection law wants is protect you from misusage of personal, sensible information. So I started thinking, well, maybe there is something that protects sensitive inferences more than usual inferences. So the next question was, is there any protection for sensitive inferences? So, and in the law itself, very promising actually, we do have the Article 9 that talks about sensitive personal data. And it says very clearly that everything is sensitive data if it's able to reveal sensitive attributes such as race, biomedical information, health status, sexual orientation. So it's not just the information that it directly gives to you, it's also information that is capable of revealing something about being considered sensitive. That makes a lot of sense, and it's very clearly here that these inferences would be covered by data protection law. Again, quite a dispute between the 2 bodies here. The Article 29 Working Party, very sensible, says that of course it's not just about the data that you collect, it's about the ability to infer something that is sensitive. So it's not just the input data, it's also if you collect it, if you assess it, and if it's able to give you insight into someone's private life. Court sees it a bit differently. This is an interesting judgment where somebody wanted to have the names of the personal assistants of members of the European Parliament. And those personal assistants said, I don't want this information to be disclosed because you could use this information to infer my political stances. If I work for somebody, a member of parliament, you might be able to infer what my political convictions are. Therefore, please don't really reveal it. The court said, nah, that's not good enough. This doesn't constitute sensitive data because in order to be sensitive data, you would need to have the intention to infer this, and the data source has to be reliable to infer the sensitive attribute, which is interesting because the court thought that just because somebody is working for a certain member of parliament, that's not enough information to infer political stances. And I think this is very troubling because both those things are irrelevant in the age of big data. Intentionality doesn't play a role anymore. We, for example, have a lot of data that is proxy data for sensitive information. For example, postcodes. Postcodes, we all know that they are a very good predictor for race, gender, sexual orientation. It doesn't matter if you want to infer that. If you use that kind of information, you're going to bake this information into your decision-making standard. It doesn't really matter if you want it or not. And the second thing is reliability. Is that really important if my prediction is accurate? Is it really important, in this case, for example, that the person is actually a member of a certain group? It's important if I think that person is a member of a certain group because I'm going to tailor my behavior towards them. I'm going to show them different content. I'm going to treat them differently. It doesn't really matter if the prediction is accurate. It only matters if I start treating people differently. So here, the legal framework is, unfortunately, still problematic. But let's just see it from a positive perspective. Let's just see the court sees it differently. The court has a very generous interpretation of what personal data actually is and sees it as something that needs to be protected. The last barrier to full transparency and accountability are trade secrets. And very often when you talk about privacy and data protection law, people say, well, I mean, that's an absolute right, and you should be able to protect your private data if you want to. The problem here is that's actually not true. If you look at the legal framework, it very clearly states that data protection law has two aims at the same time. Yes, of course, you should protect personal information, but it's also there to enable the free flow of data within Europe. And this is also clear in the Charter of Fundamental Rights, where, of course, you have the right to private life and family life and personal data, but you also have the right to choose an occupation. You have also the right to conduct a business, and you have also the right to property, which includes intellectual property rights and trade secrets. And if you look at the GDPR again, with that lovely example that I gave of the right of access, it's actually already here. Yes, of course, you do have the right to ask what data is being held about you, but you're only gonna get information about that if this information does not adversely affect rights and freedoms of others. And rights or freedoms of others is regulated in Recital 63, and that says intellectual property rights and trade secrets. Everybody was very excited about GDPR coming into force, but there was one legal framework that was completely overlooked that came into force roughly around the same time in June 2018. We have a new trade secrets directive now. And this directive is actually strengthening the protection of a lot of information. So the crucial question is, what is considered a trade secret? And I give you here like the definition that is actually in the directive. A trade secret is anything, everything that is not known. It is anything that has commercial value, and is anything where reasonable steps have been taken to keep it secret. That is a trade secret. So if you think that the definition of personal data is broad, enter this. Basically, anything can be termed as a trade secret. It could be an algorithm, it could be a model, it could be customer information, anything that has commercial value. And if we're very honest, the inferences are the personal data that is the most valuable. And just to show you that this is actually not just an academic problem, it is a problem that already caused quite some attention in the past. Here's a lawsuit that Max Schrems, Facebook's best friend, lodged in 2011 because he had a similar idea. He went to Facebook and said, I want to exercise my right of access. I want to know what kind of type of information you're holding about me. I want to know everything. And Facebook came back and said, here's some data, but we cannot give you everything. If we gave you everything, this would be a disappropriate effort. And in addition to that, this information would violate our intellectual property rights and trade secrets. So that excuse was already used in 2011, and now we're entering a new age with new laws that might even strengthen that. So, question is, what are possible solutions? What can we do? Because big data is fantastic and AI is fantastic, and I think there should be a way to combine those things in a sensible way. So the first question is, what I think is, we need to rethink data protection law. We need to think about the fact that data protection law is not just about the input data, it's also about the output data. It's not just the information that are volunteered to you, it's also what you make of it. Just to look at focusing on data protection when the data is collected is not enough. The interesting part happens after it's being collected, when it's being assessed, when it's being used for decision-making processes. This is when it's getting interesting, but we have no regulation around that. I'm not convinced that we necessarily need new laws, but we need to remember. We need to remember why we have data protection laws in the first place. And it's not about data, it's called data protection law, but actually it's not about data, it's about humans. We want to protect humans, and we want to protect their privacy. And data protection law, that is actually just a small fraction of a much bigger right, which is the right to privacy. It's just a miniature fraction of that. And I've thought about data protection law a lot and analyzed the judgments of the European Court of Human Rights to figure out what privacy actually means. We have to remember that privacy is a human right. And privacy is much, much broader than just pure data protection. Just to give you an indication of what the European Court of Human Rights thinks about privacy, this is an indication what privacy means. It's much broader than just data protection. It's about freedom. It's about tolerance. It's about the freedom and the ability to develop yourself, to express your personality. It's about self-determination. It's a right to represent yourself, to present yourself, to have a right to own your picture. It's about having the right to reputation. It's also a right that you change your personality, change your identity. It is non-discrimination and equality. It's also a social element to it. You should have the freedom to interact with friends, with family, with business partners, all part of privacy. You have the right to find a profession, and you have the right to be left alone and not interact with anybody around that. This is what privacy actually means. We have to remember that. This is why we have those laws in the first place. So it's about change. And we all change throughout that time. I have nothing to do with the person that I was when I was 16 years old. If I look back, I really don't see a connection anymore. And I think when I'm 40, I will be looking back at this point and I'll be, oh my God, what was that, right? So we are changing. We are constantly changing, and that's a good thing. But that's not really how machine learning works, right? So how does machine learning work? You put a bunch of historical data in an algorithm, and you're trying to predict the future based on the past. You look at historical data, how things used to be, try to find patterns, similarities, and predict the future with it. So you will only be accurate if the future looks like the past. This is how machine learning works. And I think it's very, very important that those kind of information is very, very useful on a population level. Right? I think big data and AI and predictive models are very good if you want to predict if there will be a flu outbreak and you can stock up the medication in hospitals or pharmacies. It might also be good if you want to figure out if the birth rates are increasing and you have to hire more teachers for schools, or if you know that there will be migration in a certain area of a country, then you have to build up infrastructure. That's perfect. That's very, very powerful. It's still a prediction. We don't know until we know. But the margin of error is not devastating. The margin of error might be devastating if you use that same thing to make life-changing decisions about an individual. If you're also always using the past to predict someone else's future, then you're going to have very often unjust feedback loops, right? You're going to have self-fulfilling prophecies in a way. You might stigmatize people. You reinforce stereotype. And I think the most important thing is you're robbing people to be the exception to the rule. And very often we have that when you apply for a job and you have people that are very good on paper and you're super excited to hire them, but they aren't the right fit and you're actually disappointed. And sometimes you give people a chance that are not good on paper and they completely surprise you. And that's the human element that we cannot forget. You are more than the data that you leave behind. And I think we need to remember this because at the other end of the spectrum, we might look into a future that looks something like this, right? We know what's happening in China at the moment. They're developing a social credit score. That means they're going to work towards to have a centralized database where they collect all your personal information from private institutions, public institutions, and they're gonna have a citizen score. A citizen score that says if you're a good person, a good citizen, or a bad citizen, whatever that means. So all your data is being collected by an opaque algorithm, and that could lead to good things. You might get, for example, discounts in restaurants or supermarkets. If you get a bad citizen score, you might not allow to leave the country, or your kids are not allowed to certain universities. So this is the other end of the spectrum. It's possible from a tech perspective. It actually is happening, and I think we have to make sure that we remember that we're being more than the data that we leave behind. So what we are proposing is a right to reasonable inferences to counterbalance the current imbalance between those things. So how do we think about that? I think there is no one-fits-all solution. I think the right to reasonable inferences is something that is important for high-risk inferences. So when data is being used to make very important decisions about you that are life-altering, and we need to look at specific sectors to find a reasonable threshold for that. I think it's important that we look at criminal justice for health, for example, employment, advertisement, insurance, and look at this at a case-to-case basis and find out what is the reasonable standard for decision-making and data collection in that. And the way that we are proposing that is to say you should have a right to reasonable inferences for high-risk inferences if they're very privacy invasive or reputationally damaging, if they have very great predictive power or opinion-based, so we actually cannot verify it, you can contest it in any way. And if you have that, you should have a right to ex-ante justification. The question of, is the inference that I'm drawing relevant to the decision that I'm making? Is it normatively acceptable? Is the data source that I'm using relevant or acceptable for the decision that I'm making? Is the method that I'm using actually reliable for the prediction that I'm making? And if it's not, you should have a right that this has been explained to you, and you should be able to contest that. So in a way that I would like to think about that with the question of ex-ante justification, relevant about the inference. Is the inference normatively acceptable? Are we okay with Facebook inferring sexual orientation to offer you gay cure advertisement? Is that something that we want to have? With regards to the data source, how do we feel about the fact that all your search engines interactions are being monitored and currently assessed? Is that too privacy invasive? Do we need standards around that? In terms of reliability and methods, the example that I gave you here, is it reliable? Are your friends a reliable predictor to determine whether you're going to repay a loan or not? Do we have statistical evidence that suggests that this is actually something that can be defended, or is it not? And if it's not, then you should have a right that this is being contested. You should have a right to being heard. I'm not saying that you will change people's mind. I want to open up a dialogue. I want to open up the opportunity for an individual to enter into a conversation. In the same way that I can tell you, I don't like coffee, I like tea, that doesn't mean you have to change your mind, but at least we had the ability to talk about it. And that's what we're trying to do here. We want to open up a dialogue to readjust the power asymmetry. Because big data is fantastic, it's very helpful, and I'm very excited about the technology, but I think the future of AI requires a good dialogue between developers and society to not just figure out what's technically possible, but also think about what's reasonable. Thank you.